Okay, everyone, we're going to get started. Hi, my name is Jayashri Srikantiah. I direct the Immigrants' Rights Clinic here, and I'm delighted to be asked to moderate this wonderful panel that the Levin Center is putting on. We struggled a lot with the title of the panel, but our focus is on government discrimination in the name of national security, broadly termed. And what we can learn by comparing the Japanese incarceration context and current discriminatory policies that target Muslim Americans and Muslim immigrants. It's a complicated topic, and Dale Minami, who I'll introduce in a moment, reminded me that there are similarities and a lot to be learned, but there are also differences and a lot to be learned from the differences as well. And of course, there's also the overlay of immigration on top of the whole thing and immigration policy and its changes. So it's a complicated topic, and what we want to do today is introduce you to it, get us started in the conversation about it, and hopefully so that you and we can continue these conversations after this panel. So let me start by introducing the panelists. I'm so lucky to be able to moderate this panel because I know both Dale and Shirin, Professor Sinnar, and Shirin worked with me as an intern a long time ago, so it's hard for me to call her Professor Sinnar. But anyway, so both of them are incredibly zealous advocates, but also really thoughtful and reflective about their work. And so I think it's going to be a great discussion. Dale has such a long bio that when I looked him up on Wikipedia...
That's because I'm old.
It's kind of daunting to even think about how one might summarize it, so I'm not going to do that justice, but just to give you a quick thumbnail sketch, he's right now a partner with Minami in San Francisco and has been recognized in numerous different contexts as one of the top personal injury lawyers in the Bay Area and has won a lot of awards, including Super Lawyer in Northern California, Northern California's Best Lawyers, and one of the 500 Best Lawyers in America. We've invited him here today because he's also a civil rights hero and legend. He successfully litigated Korematsu v. United States, which was a lawsuit to overturn the 40-year-old conviction for Mr. Korematsu's refusal to obey exclusion orders aimed at Japanese Americans during World War II. He's also represented numerous other Asian American clients in civil rights lawsuits. He's a co-founder of the Asian Law Caucus, co-founder of the Asian American Bar Association of the Bay Area, and the Asian Pacific Bar of California. He's received numerous awards as well for his civil rights work, including the ABA's Thurgood Marshall Award, which is one of its top awards, and the Spirit of Excellence Award, NAPABA, which is the National Asian Pacific American Bar Association's Trailblazer Award, and the ACLU Civil Liberties Award. So we're really, really lucky to have Dale here with us to share from his experiences and wisdom about what we might learn. And then to Dale's right is Shirin Sinnar. Shirin, as you know, is a professor here. Her scholarship focuses on the role of institutions, including courts and executive branch agencies, in protecting individual rights and democratic values in the national security context. She's done wonderful writing in this topic and has numerous projects in the works, and as well comes from a background of litigation and advocacy. Before she came to Stanford, she was a public interest attorney with the Asian Law Caucus and the Lawyers Committee for Civil Rights in San Francisco, where she represented individuals facing discrimination based on national security policies and unlawful employment policies. So I'm not going to spend any more time on the introductions. Let's jump right in. What I thought I would do for the format for today is to have Dale and then Shirin give us a little bit of background and context for about 10 minutes each. Then I'll ask them a couple of questions, and then we'll open it up for questions from you, because I'm sure you have quite a few. So Dale, if you could start with giving us an overview of the discriminatory federal government policies against Japanese Americans and Japanese immigrants during World War II, and also what are your thoughts about similarities, differences, lessons learned, and just kind of some framing.
10 minutes. I'll go.
10 minutes.
I have to talk really fast. I feel like I'm in the first row of a movie house theater, but so it's a little bit different. I guess we go back to World War II, and we're going to start there. How many people have know about the internment or incarceration of Japanese Americans during World War II? That's pretty good. How many people have read or heard about the Korematsu case, the landmarks or Hirabayashi? These are a couple facts that inform me on how much I need to go into detail, because we teach whole courses on this issue. But in World War II, after the attack on Pearl Harbor, which was the Day of Infamy as termed by President Franklin Delano Roosevelt, began years of infamy as Japanese Americans were rounded up, put into first horse stalls at Santa Anita Racetrack in Tanforan, which is close by, and then taken to the nether reaches of this country and God forbidden imprisonment, basically. There were no charges at the time, and 120,000 of them were Japanese Americans, 2/3 of whom were citizens. They were not given a trial. There was no due process. There was no right to lawyers. There was no notice of any charges. The original justification was military necessity, which is the same as national security if you just use a different terminology. And the justification went a little further, but it was pretty shallow, that in times of war, ethnic associations could determine your loyalty. So Japanese Americans, all of whom were suspect at the time by certain government officials, and not everybody shared that view. Among those who were taken were my parents, my grandparents, our whole family, my then 1-year-old brother, who was, if you take this further, thought of as a potential saboteur or spy, despite his ability to speak language or even walk. And at the end, after being incarcerated without charges for an indefinite period of time, which is familiar to many of us in today's situation, they returned to the West Coast, most of them. A lot of them went to other parts of the country because they were not welcome back here, and tried to make their life over. Years later, a commission was formed by the Congress that examined the causes, the facts, and basically concluded that there was no evidence to imprison Japanese Americans. There was not one act of espionage proven, not one act of sabotage proven. And the commission concluded that the causes of the incarceration was race prejudice, war hysteria, and the failure of political leadership. It's a situation that you could probably apply today when you're talking about discrimination against Arab and Muslim Americans. Immediately after World War II, in February 19th, 1942, President Roosevelt issued Executive Order 9066. That was an order permitting the military commander in the western region, where nearly all Japanese Americans lived, to make orders to make sure the area was secure. He immediately ordered a curfew, then the exclusion of all Japanese Americans who had at least 1/16 blood in their veins to report to, first, like I said, some of them went to racetracks or assembly centers, and then to 10 camps around the country. After that, Congress passed a law making any violation of the military orders a criminal offense. And later on, 3 men stood up and 1 woman to challenge those orders, which were eventually validated by the Supreme Court. So all 3 branches of the government were complicit in this essentially racist act of taking this ethnic, racial group of people without any due process and putting them in prison for an indefinite period. Japanese Americans were isolated at the time politically. They did not have a lot of allies. So nobody stood up for them. The ACLU, National ACLU, was supportive. Groups like the Socialists, the National Lawyers Guild, nobody stood up for Japanese Americans except the Northern California ACLU chapter, which was threatened with expulsion for supporting the Japanese Americans. Southern California also stood up too, but they were a little bit later, but they also helped out in fighting these what we feel were unconstitutional orders. The 3 men, those cases went to the Supreme Court first at different times. The Supreme Court, and I can't give you all the details, in an amazing series of manipulations of the procedure and the law, essentially ruled first on the Hirabayashi case. He was a Quaker from Washington, University of Washington. There's also Min Yasui, who just received the Presidential Medal of Honor. In fact, all these three men received the Presidential Medal of Honor for their stance because of the recognition that what happened to Japanese Americans was a travesty and ruinous of people's lives. So their cases went to the Supreme Court. They all thought they were going to win because it was clear. They only took en masse Japanese Americans. There was no trial. It was racially based. And a remarkable set of opinions, especially the Hirabayashi and the Korematsu case. The court was confronted with a record that was barren. There was no expert testimony, no witness testimony. There was no evidence of espionage or sabotage. There was no evidence of any misconduct, except there was manufactured evidence, which we found out 40 years later. There was a fraud essentially committed on the Supreme Court in those cases, which the Supreme Court could not appreciate at the time. And I'll talk a little bit about that later. But the Supreme Court, in that remarkable set of decisions, established the principle, which is pretty much discredited at this point, very much discredited at this point, that you could uproot an entire race of people without a hearing, without notice, without due process, and send them to indefinite confinement to the nether reaches of this country. And while we've heard about that, and it's happened to some degree to Muslim and Arab Americans, it hasn't happened on the scale that happened to Japanese Americans. The Supreme Court dodged all the issues and essentially deferred to the judgment of the military, which said they're dangerous. That was it. There was almost no other evidence. So they adverted to peripheral facts. Japanese Americans sent their children to Japanese language schools. They worshiped the Shinto religion. They lived near military installations, even though the installations were actually built after the Japanese were settled there. They had these characteristics of being disloyal. It is pretty much a revival of the old inscrutable argument, which was used throughout Japanese American history and Asian American history, that you can't understand these people. They're from a foreign country. And that's part of the immigrant dynamic of that whole school of thought. And so because we can't understand them, we cannot trust them. In fact, that was the official reason proffered for one of the General DeWitt, who issued the original orders, that you can't separate the sheep from the goat. Well, that evidence was destroyed because it would not fly in the Supreme Court. It was obviously too racist. And later on, when it was discovered that that evidence was destroyed, except for one copy of his book that was discovered, changes were made. It helped our case later on when we reopened their case. People look at the exclusion of Japanese Americans as an aberration, but it really was a culmination of a century of racism directed at Asian Americans. From the first Chinese Americans who came here and who were welcomed as immigrant cheap labor, it's quickly soured in the discriminatory laws, segregation, inability to go to schools, and then prohibitions against employment were enacted, which were directed at Chinese Americans. Until 1882, when the first Exclusion Act, excluding an entire race of people in this country, it was ever enacted, the Chinese Exclusion Act. The Japanese filled that labor void and suffered the same types of, same situation. It was a repeat of what happened to Chinese Americans. Initially welcomed for their labor, but because of their, quote, foreignness, were soon the subject of discrimination, both in schools, in employment, in the ability to own land. In 1924, another Exclusion Act was passed, which excluded Japanese Americans, a second racial group. So what seems like, and people teach it as an isolated act, was not an isolated act. It really was part of the rivers of racism that run through this country that affect all people of color. And so whether it be slavery, whether it be the Chinese American experience, or the Japanese American experience, the same, I think, thinking that also discriminates against immigrants of color or people of color in general has continued to this day. So I think what we see as part of a pattern, it's considered one of the tragedies of American history. Korematsu has never been overruled, but surprisingly, and I've done some research on this on the Guantanamo cases, it's never really been cited for a proposition to allow discrimination against an entire group of people. If anything, it's cited for the idea that we should have strict scrutiny. Ironically, the birth of strict scrutiny was Korematsu versus the United States. And yet the court did not apply the strict scrutiny, and in fact said that in a remarkable statement. Korematsu was not excluded from the military areas because of hostility to him or his race. Surprisingly, what is the reason he was excluded other than his race? And the second fact that I think to be considered is that if Japanese Americans were so dangerous, why weren't the Japanese Americans in Hawaii taken away en masse, which they were not? The attack was at Pearl Harbor in Hawaii. The largest concentration of Japanese Americans were in Hawaii. The Pacific Naval Fleet was in Hawaii, and yet Japanese Americans were not taken away. So it points the finger to really the racism that occurred not only in California, but the lack of information and ignorance about Japanese Americans throughout the country. Just a side note is if you read a book called By Order of the President by Greg Robinson, there's also some background about FDR and suggestions and overt things that he was essentially a white supremacist who believed in eugenics. And he quotes letters of FDR, which, you know, I was a big FDR fan until I read this. But I still am to some degree. But it was not surprising then that he perhaps did not have the type of empathy or broadness of vision to understand Japanese Americans in this country. So that's the conclusion at this point. 40 years later, we're going to come back to these cases, and we'll see what happens.
Thanks, Dale. Shirin, I was hoping that you could provide some of the context, and it's hard to know what the starting point is. I actually was thinking about that before today. You know, when do you start looking at the discriminatory laws against Muslim Americans? I mean, 9/11 is certainly an inflection point, but it wasn't the start. So you can choose where to start, but maybe laying out some of the framework.
Sure. So I think actually before talking about discrimination against Muslim Americans, I want to start from the more general question of, you know, why are we talking about Japanese American incarceration today? And, you know, of course, one reason is that since Paris and the San Bernardino attacks, there's been a lot more public discussion of the incarceration. And sadly, what once was a near consensus that this, you know, was one of the most shameful experiences in our national history, that consensus has now come under question and attack. And so whether it is, you know, some political officials actually calling for internment, whether of Syrian refugees or Muslims, which, you know, thankfully those calls are still in the minority, or, you know, politicians like Donald Trump reflecting on the internment and saying, I'm not sure where I would have stood. It, you know, would have been a tough decision, you know, whether or not to intern people during World War II. Or even, you know, a year ago, Justice Scalia telling an audience of law students that if you think that the Korematsu and other decisions finding the internment to be lawful would not be repeated today, then you're kidding yourself. You know, here's a justice of our Supreme Court telling us that he thinks that that is something that a modern Supreme Court could well, you know, find again if, you know, circumstances presented themselves. So, you know, understanding and appreciating the history of the internment, the incarceration, is important on its own terms, but it's also critically important for us today because of the lessons that people are seeking to draw from that experience, you know, for our own national security policy. So what are those lessons? You know, I actually want to start first by talking about what I think might be the wrong lessons to take away from the internment. And the first, I think, wrong lesson, but one that has been suggested in kind of recent years, is that we should think of the internment as wrong primarily because of the enormity of the deprivations that it imposed. Okay, so this is the way, for example, that Eric Muller, who's a historian of the internment, who's written some fascinating, incredibly important work on the internment, what he suggested, about a decade ago, that it's the enormity of the deprivations that's the central harm of the internment. In my view, the internment was wrong, particularly because it involved the wholesale exclusion and detention, for years of families and individuals, on nothing more than the basis of their Japanese ancestry. But the internment was wrong not only because it involved that magnitude of deprivations. And I think this is important because if you think of internment as problematic only or mostly because of the scale of the laws, then it's easy to say, hey, look, we're not interning people today. It's been 15 years since 9/11. We don't have internment camps. Muslims aren't in general en masse being subject to confinement. And I think that's true. But I think that if we draw from that the idea that therefore we have learned as a society, therefore those mistakes are behind us because we're not doing exactly the same thing as we did in the past. We're not repeating the exact same historical mistake in quite the same way, then I think it causes us to lose an appreciation of some of those broader lessons. And I'll come to what I think those lessons are. And a second lesson, though, that I think might be the wrong lesson to take away is that the primary wrong of the internment was that the government knew that the Japanese American community was disloyal, but hid that fact from the courts and the public. And I think, that's very much true. That is part of the history. The Solicitor General from a couple of years ago actually apologized because there was evidence of intelligence reports that were suppressed and not even provided to the Supreme Court when the Solicitor General was advocating in the Korematsu and Hirabayashi and the other cases. And it is also true that not a single person of Japanese ancestry was convicted of espionage or spying for Japan. But if you look at that and then you draw the lesson as being the Japanese Americans were actually loyal, then it leads people to say today, the Japanese Americans were loyal. There was no threat. But look at today. There have been acts of American Muslim terrorism. We've had San Bernardino. We've had the Boston Marathon shooting. So, these situations have nothing in common. If the primary lesson that people focus on is that ultimately no threat was realized and the government hid evidence of misconduct, then I think we don't ask the questions about group-based presumptions of disloyalty that need to be asked. So, to my mind, the fact that the government concealed that information, the fact that no threat was ultimately realized makes the internment experience particularly egregious in how our political institutions, our judicial institutions responded to it. But it shouldn't be the sole or most important takeaway from that experience for us today. So then, what are the relevant and more general lessons of the Japanese American incarceration for today? First is a lesson, this is actually, I think, similar to what the Congressional Commission concluded, is that in times of war, perceived security crises, fear, prejudice, and political opportunism trump facts. No pun intended. Okay. We know how large a role racism played in World War II era discussions on Japanese American loyalty, and Dale talked about some of that overt racism, and how it also didn't arise overnight, but it was, the internment experience was a culmination of kind of decades of legitimation of anti-Asian, anti-immigrant exclusion and racism. And so by the time of World War II, somebody like General DeWitt, who directed the Western Military Command, could say the Japanese race, here's the quote, is an enemy race, and while many second and third generation Japanese have become Americanized, the racial strains are undiluted. It therefore follows that over 112,000 potential enemies of Japanese extraction are at large today. They are unassimilated, a tightly knit racial group bound to an enemy nation by strong ties of race, culture, custom, and religion. Now, when we look at current rhetoric about Muslims, Muslim Americans, and Islam in the US, we see a set of recurring ideas, here actually and in Europe even more so. Muslims don't want to integrate. Islam is innately violent, misogynistic, and authoritarian, so that anyone who considers himself or herself Muslim, by definition, must believe in those ideas and is inherently presents a threat of violence and a threat to democracy and democratic values more generally. Those views have been promoted by far-right institutions, well-funded far-right institutions, and have increasingly entered the mainstream of our political discussion. So then when we hear somebody like Donald Trump making the outrageous and utterly false claim that thousands of Muslims in New Jersey were celebrating the 9/11 attacks after they happened, that kind of, that's a blood libel, right? It's, similar to accusations in the past against other religious minority groups. The idea that you were celebrating, the murder of 3,000 people. And to say that, not even to backpedal when he pointed out specifically that is, utterly discredited, there's no source of that. And yet to continue to assert that, that's kind of the I guess, one of the more provocative of the assertions, but my broader point is that comes as part and parcel of a growing climate of hostility to Islam and Muslims that has been actively promoted by certain political organizations. So I can talk more about that, but just to move on a little bit and to kind of draw on a second but related lesson from the internment, is that these kinds of security fears and race-based assumptions and so forth then prompt group-based presumptions of disloyalty that seriously harm racial, ethnic, and religious minority communities. Okay, so I want to talk more about these presumptions of disloyalty and just briefly address two examples of policies in recent years that I think embody that. So first is the mass detentions of mostly Muslim men in the 6 months or so following the September 11th attacks. Many of you may have been too young to remember this in real time, but all of you have read Ashcroft v. Iqbal and Civil Procedure, so you have at least some exposure to these facts, although you probably remember the decision, if at all, mostly as a decision about pleading standards rather than for the underlying facts. Back to the facts. So I want to focus just on the facts from a report produced by the Inspector General of the Justice Department, which is an independent oversight institution within the DOJ. This came out in 2003. So the DOJ IG found that essentially within 2 months of the attacks, the government had arrested and detained 1,200 citizens and aliens nationwide in these sweeps. Many came to the attention of law enforcement because neighbors essentially called up the FBI or police to report their Middle Eastern-looking neighbors acting suspiciously. And despite the plainly racial and religious basis for many of the tips called into law enforcement that then prompted the FBI to go forward and arrest people on immigration violations, over 100 of these immigrants were designated and held as special interest detainees for many months in highly restrictive conditions, no access to lawyers, no contact with family, maximum security conditions. Prison guards called them terrorists, physically assaulted them. These allegations were substantiated actually by videotape evidence found of it by the Inspector General. And the IG ultimately concluded that federal officials knew pretty early on that there was nothing to connect most of the people in detention with the 9/11 attacks or any acts of terrorism. They knew that. They knew how little had motivated the original arrests in the first place. Yet, they continued to be held for many months at a time. And ultimately, not a single one of these detainees was charged with a terrorist crime. Okay. The second example, still more recent, is of these group-based presumptions of disloyalty and how they manifest in our policy, is the New York Police Department's surveillance of Muslim communities in the New York and kind of greater East Coast region over a period of many years. There's a Pulitzer Prize-winning investigation by the Associated Press some years ago that exposed and documented this. But essentially, the NYPD was sending officers and informants into every Muslim, not just mosque, grocery store, neighborhood, restaurant, bookstore in the greater New York area to create, to essentially to map out the activities and lives and institutions of the entire community. So informants were sent out to hang out in these venues. Again, no individual basis for suspicion of any of these particular places. They were essentially told, this was a demographics unit, that's what it was called, go out, sit at Muslim restaurants, and just listen to what people are saying. Go to the mosque, record what the imam is saying in his sermon. The NYPD intelligence chief, who came from his background CIA, and he was brought into the NYPD after 9/11, he essentially said, I want to have an informant in every single Muslim institution and mosque in this area. So that was the objective. And mass surveillance was conducted on the entire community, citizens and immigrants alike, for a number of years. Okay. There are other lessons, but I think I'll end there and let Jayashri start.
All right, so I'm going to ask a few questions, and I'm sure you have questions as well. But I don't think we can even move forward without Dale telling us a little bit about the Quorum Nobis effort that he led to address the wrongs, at least in part, of what happened to Mr. Korematsu.
How many of you even heard the word Quorum Nobis? Think of habeas corpus. How many have heard of habeas corpus? It's pretty much like habeas corpus, folks. But essentially, this was a petition we made because we found some evidence through a researcher who was writing a book and essentially a housewife who was researching the Smithsonian, the archives, to find out why she was plucked out of Los Angeles High in the middle of her junior year and taken away to these camps. And she was just outraged and inspired to try to find out. So they happened to converge together, a New England Caucasian man and a Japanese-American woman from Southern California. And they discovered a set of evidence that was remarkable because it proved through the words in letters or memos of the government officials who were lawyers at the time that the United States Supreme Court was lied to in 1943 and 44 when the Korematsu, Hirabayashi, and Yasui cases were decided. These are landmark cases, as I mentioned. And they found memos. The first memo Peter Irons, who was one of the lawyers and a researcher, discovered was a memo from one of the deputy attorney generals to the solicitor general saying that we are telling deliberate lies in the Supreme Court. It is highly unfair to this minority group that these lies go uncorrected. The lies they were talking about are claims by the military that there was espionage going on, ship-to-shore signaling and shore-to-ship signaling on the West Coast. That was refuted by J. Edgar Hoover and the Federal Communications Commission saying he's absolutely wrong. That never happened. There were reports that Shirin mentioned about recommendations made by officially designated intelligence officers saying, look, we've studied the Japanese-American community for years, and there's no reason to incarcerate them en masse. You could do individual hearings like they do in Britain. Several other reports came to the same conclusion. Those reports were suppressed deliberately from the Supreme Court. And instead, a version of who Japanese Americans were is the group presumptions that because they were Japanese, they're inscrutable, they're foreign, that they're probably disloyal. And that presumption then became pretty much the through line for which the Supreme Court made its decisions. Well, these official reports and the admissions, really, by government officials, the lawyers, that this was a fraud on the Supreme Court were discovered. And Peter Irons, who happened to be a lawyer, who by coincidence had been convicted of a draft violation and brought his own quorum nobis action, called me up one day, and I was in Oakland in my office, and I thought either this guy's crazy or he's onto something. He said, I found evidence that we can overturn the Supreme Court case. I asked him, are these guys still alive? Because, you do these kind of cases, and you read about a Korematsu, but it's such an abstract concept that you study in law school about the collision of rights, the war powers versus equal protection. And so, the individual, the drama, the human history, the human drama is pretty much leached out of those cases that you read. So the surprise is like if you saw Pinoy or Neff walk into this room, where Mrs. Paulsgraf comes in. It's something, whoa, there's real people. So we found out they're still alive, and they wanted to bring the case again to overturn their conviction using the quorum nobis, which we also had to look up by ourselves because we didn't know what it was in Black's Law Dictionary. They still had them in those days. And so we embarked on this 3-year journey to get their convictions overturned because of a fraud on the Supreme Court and manifest injustice. We put together, and I had to have contacts in Portland and Seattle because we had to bring these 3 men's cases. There are 3 men who challenged it in the venue of their conviction. And I happened to know a legal aid attorney, Peggy Nagai, who then went on to work with Derek Bell at the University of Oregon, and my former law clerk, Catherine Bonai, who then was agreeable to accepting the lead counsel role for Gordon Hirabayashi. So we set up a meeting. Peter sent us the evidence, and it was exactly like he said. There were 5 or 6 memos that were just saying, we are lying to the Supreme Court. We cannot do this. And yet the Solicitor General ignored their pleas, went ahead with arguing in the Supreme Court the very lies that he knew were untrue, and without the evidence that could have explained or undercut the military necessity argument by these official reports. We brought the actions in 3 different venues, and we went to San Francisco first because we had the best panel of federal judges. Because it's all by chance how you get federal judges in San Francisco. So we handed the petitions to the luckiest member of our group. She, of course, knew how difficult this was going to be. And when the clerk called out, you got Marilyn Patel, whom we knew to be a liberal, brilliant, fearless judge, whom I had actually wrote a letter of recommendation to Jimmy Carter when she was appointed because we knew each other. We were high-fiving in the courtroom. We were so thrilled. It was very undignified. So the strategy was then to delay any of these filings. We want to get a head start. If we got a good judge here, if we got a bad judge here, we'd go straight to Seattle, which was the second best panel, and then file there immediately so we could try to move that case ahead of everyone else's with a good judge. If that failed, we'd go to Portland, and we'd be screwed. So, because there was no good judge there. For this kind of case. But luckily, we got Marilyn Patel. We proceeded with our preparations the year before, pretty much in secret, because we didn't want any other documents to get disappeared, like we had seen in other situations with the government. And so we then were able to present a full-blown petition with exhibits. We had expert witnesses lined up. And Marilyn Patel, the judge, tells people at the time, she goes, I never heard about this. I just, in law school, the last time I heard about it. So I guess they taught quorum nobis then. And when we filed the quorum nobis petition, the clerk of the court had to come out, the official U.S. clerk, to say, because they didn't know how to file it. They said, I haven't seen one of these in about 20 years. And he said, how did you want to file this? Is it civil or criminal? And I immediately said civil. And because it's a hybrid action, and obviously the reason you do civil is you get discovery. You don't get it in criminal cases that much. So I said civil, and they just filed it as a civil case. We were able to send out interrogatories, requests for production, et cetera. It was wonderful. As we went along in this whole process, and I'll wind up pretty soon, they offered Fred Korematsu a pardon. And they said, we researched it. We said, well, a pardon just excuses the punishment, but you're still guilty of the crime. Fred says, no, I don't want a pardon. So then they came back 2 weeks later and said, we're going to offer him a pardon for innocence. And we said, what's that? And they said, well, we just made it up. Because we wanted a finding of innocence. So we took it to Fred. Fred and his wife said, we don't want a pardon. If anything, we should pardon the government. It was a beautiful statement that he made at the time, and we were then proceeding to trial. The Justice Department was conflicted. They didn't know what to do with this case, and they hawks and doves in the Department of Justice. They couldn't make a decision on how to respond. So Justice Patel came forward and pushed them along. And the reason we had some urgency is we had brought this case in the middle of the redress and reparations movement. It was a movement by Japanese Americans started in the 70s that was demanding of Congress to an apology and $20,000 in reparations. It's fairly unprecedented, and if we were, the Congress people were blocked by the original Korematsu and Hirabayashi decisions, which validated what happened to Japanese Americans. So our risk was we lose the case and we become pariahs. We would have to be discredited for the rest of our lives for losing the case that lost Japanese Americans redress, probably. And at the same time, the stakes were raised because Supreme Court Justice, or ex-Supreme Court Justice Arthur Goldberg, had gotten wind of our case and said, this is foolhardy. It will set the redress movement back if you bring this case. And we talked to our group, and we debated this for only about 5 minutes. We said, he doesn't know what he's talking about. He's full of shit. Because he does not know what the evidence was. He does not know Marilyn Patel. And, if we're going to get one shot at either vindicating these three men's courageous stand, to rewrite history, which we had to do because there were people who all felt that the incarceration had some basis in fact, which it did not, or justification. And three, we wanted to put another nail in the Korematsu precedent that you could exile an entire race of people without due process. So the stakes were pretty high, except that we kind of had the wisdom of fools or of young people. And we thought, so what if we're demonized for the rest of our lives? We'll still do this. But we had the great evidence. And eventually, to fast forward, Marilyn Patel overturned his conviction and said that there was deliberate misconduct, there's racism, that there was a manifest injustice. She ended with a beautiful quote, which I wish I could say, I could have quoted because it's relevant today, that in times of war, in times of hysteria, our nation's institutions, judicial, executive, and legislative must be even more careful to guard the civil liberties we cherish so much. And that was a pretty much both prophetic and wise, because that same issue and that same situation applies to this day.
Thanks, Dale. I'm going to open up pretty soon for questions, but I'm going to ask one more, which is just to look back, and maybe Shirin, you can start. If you think about the political failures that led mainstream Americans to kind of stay silent, I remember the times after 9/11 when I was at the ACLU and working on those issues, that it was very there weren't a lot of people coming forward and saying, it's wrong to round up hundreds of Muslim men and detain them without charges, without attorneys, in secret. We would call and couldn't find out where they were. We didn't even know their names, so it was kind of this reverse problem of not knowing where somebody's detained. But it was almost a controversial stance to take a controversial thing to take a public stance against it. And I wonder if you could just talk a little bit about, what can we learn from that political failure, or what political failures led to that kind of situation, and are there lessons that we can take from there to now, when once again it seems more legitimate to say outlandish things such as prohibiting all Muslim immigrants from entering the United States, or one of the kind of Trumpisms.
Right. Yeah. So just one thing on those detentions. During that time, I recall, and I think anyone who was, of an age that they would be paying attention to the news would remember that at that time, the Attorney General would get on TV and say, we've now arrested 200 people, and now it's up to 300 people. It was being talked about publicly to reassure the public that, look, we got this, and so, for the longest time, to think of those detentions as being problematic, or to even ask the question, what were they based on, was hard to do in a climate in which the numbers are being celebrated as evidence of an effective anti-terrorism response. On the failures of political leadership, I think this is really, really important and really key, because we sometimes have a tendency to think that, okay, well, in times of crisis, violence happens, threats occur, and therefore there are natural reactions that people have, and the policies are simply an outgrowth of those natural fears and hysteria. But just one point I would want to make on that is that there's some fascinating public opinion polling actually on anti-Muslim sentiment in the U.S. in recent years, and you might think that anti-Muslim sentiment would essentially track incidents like 9/11, the Marathon bombing, San Bernardino. The incidents of violence would be the fulcrum in which sentiment goes up or down, favorable views versus unfavorable views of the Muslim community. In fact, what some political opinion scholars have shown is that public opinion and sentiment is correlated not so much with incidents of violence, but with the domestic politics that ends up, how the domestic political actors react. And so here are a couple of examples. Post 9/11, views, anti-Muslim sentiment apparently did not actually go up. It actually went down for a period of time because President Bush got on national TV and said, the actions of the 9/11 hijackers do not represent Islam. And he said that in a very public fashion, days after September 11th, and that had an impact on people not turning against their friends and neighbors to the extent that they otherwise might have done. Now, when do we see anti-Muslim sentiment peaking the most in recent years? 2008, 2012, election years, right? The 10-point gains in anti-Muslim sentiment on the part of particular Republican voters coinciding precisely with the election cycles. And I think that's important to keep in mind, that what political actors do, what our leadership does, what candidates do, do they seek to stoke fears for political gain? Or do they seek to put those fears in perspective and say, yes, these are security threats, but they're not existential ones, and we need to, deal with our threats in a measured, sensible way, while, while talking about our national strength and resilience and unity and solidarity with minority communities. So what political actors do matters crucially to the sentiment of the public at large.
So let me open it up for questions, just so we have time. Yes.
I was wondering if you could talk a bit about the resistance to the incarceration of Japanese Americans, to the extent that there was any, and then what lessons we might be able to derive from that resistance and other periods in our history that we could bring to bear in today's world.
In 1940s, World War II, there was very little resistance to. Oh, you mean resistance by the Japanese Americans or by the outside?
Either.
The resistance included the three men I talked about. One woman also, who also brought a habeas corpus and eventually won, and that's a whole other story. So there was in terms of camps, there were a number of people that took different routes, and I was just talking to Titi about that because there's a play in Broadway now called Allegiance that tracks some of the different responses. There's a group called the Heart Mountain Resistors, and there were, I think, 27 or something men, or maybe more, who signed a declaration saying, we have a social compact with this country. We will go to war and fight to death for this country as long as it lets our people out of camps. And they were convicted, they were sent to prison, eventually pardoned by President Truman, because their act was a principled stand, and that was part of the resistance. Other resistance, there were a number of Japanese Americans who resisted, went to court, but their cases were dismissed or settled. Others took a little different route, became truly pro-Japan, and they formed their own internal, and if you could call that resistance, it was in their own way, send us back to Japan. And some of the people, of course, were sent back. Some of them regretted that very much, in a war-destructed country. So there were very different models of resistance by Japanese Americans. They were not publicized, and their stories were really discouraged and suppressed as Japanese Americans wanted to re-enter the American society and be 100% American and lose any traces of Japanese, which is how I grew up, which is why my Japanese is so terrible. outside of the camps, there were pockets of resistance. There were a lot of Caucasian Americans who supported Japanese. It wasn't organized, though. They were isolated, and usually they were either criticized for their pro-Japanese leanings. The greatest amount of resistance happened in Hawaii, where some of the commanders there, the military commanders, the governors, some of the politicians who were really friends with a lot of these Japanese, because they were very much more integrated into Hawaii, stood up for Japanese. And I mean, they went to visit Eleanor Roosevelt, who was very liberal. They did all kinds of things to maintain, in some ways, flouting the rules that were told to them in orders to allow the Japanese not to be mass incarcerated. So Hawaii had a whole different reaction because of the sympathy of some of these leaders and some of these powerful people. Outside of the camps, the prisons, I call them the camps, they're not camps. Outside of the prisons, again, you had these different pockets of sympathy. There were a lot of Caucasian Americans who were friends of the Japanese that preserved their property, went on the radio to decry the kind of treatment Japanese Americans had. But the disappointment really was with the major institutions, the ACLU's Socialist Party. All the political groups almost never supported Japanese Americans. And one last point I'll make is that's in stark contrast, and my major point here is politics. That's what you're talking about, is that in 1988, Japanese Americans got redress and reparations. President Reagan signed a bill, and at that time, Japanese Americans had allies of all color, all races and ethnicities, who marched together on the journey to get Japanese Americans redress. It's a lesson we learned from African Americans and Latinos, that if you don't assert your rights, you're not going to get them, because they're fragile. And so in 1988, the lesson there was by creating these alliances to create political power, then you could safeguard not only your rights, but you could attain something which was considered an impossible dream. So that was the difference between 42 and 1988.
Shirin, I was wondering if you could talk about that a little bit, because one of the differences from the immediate post-9/11 context, where I think there was a lot of isolation, much more so than now, of Muslim communities, were much more isolated, and the groups, the civil rights groups hadn't formed, some of them, to now where there are vibrant, active, well-funded Muslim American civil rights groups and South Asian and Arab American civil rights groups that are forming these coalitions and are parts of these larger coalitions. How has that affected things? Has that had a difference, and how would you describe that?
Now, I think that is a strong and optimistic contrast between this time period. And actually, just to start with Korematsu himself, Fred Korematsu, and I think Gordon Hirabayashi as well, signed on to amicus briefs in the Supreme Court, protesting preventative detention regimes established in the post-9/11 context. And the Korematsu family, Karen Korematsu, his daughter, has remained an outstanding advocate on behalf of civil rights for the Muslim American community. So many in the Japanese American community, there are actually now, for many years, joint pilgrimages to internment camps held by Muslim and Japanese American organizations. So in terms of this very parallel that we're talking about, the experience, many people in the leadership of the Japanese American community today have stood with Muslims and Arabs and South Asians as they face these struggles. More generally, I do think that the importance of political coalition building is key. And when we think about policies and have they been rolled back, have they changed? There are a lot of policies that we look back at what people were litigating about 10 years ago, and it doesn't always feel all that different. It feels like there have been a lot of losses, especially if you think about the courts as the focus. There have been a lot of losses, and losses more in the sense of where courts have just kind of, as in the Korematsu context, saying it's not for us to judge. We can't move forward. And whether the doctrine they cite is standing, whether it's pleading standards, whether it's the state secrets privilege, whether it's Bivens claim. There are any number of doctrinal bases that can be offered, but the point is the same. We're not going to, it's not for us to judge. So that's been a disappointment, but I think where policies have been reformed, or where things have moved better, it is often through the political coalition building. So in New York, for instance, the coalitions that formed between people concerned about stop and frisk detentions by the NYPD and people concerned about anti-Muslim, the surveillance of Muslim communities in New York, those coalitions, have borne some fruit in recent years in changing some of the policies. Not enough, for sure, but in making at least some change beyond where, compared to where we were, 4 or 5 years ago.
Can I make one point? One interesting fact to me, in the day after September 11th, September 12th, the Japanese American Citizens League issued a press release and made calls to the Arab and Muslim groups saying, we're with you, we support you. And the Japanese American National Museum did that right the day after as well. And I was never so proud to be a member of those organizations when they stood up and said, we're your brothers and sisters. We don't want this to happen to you like it happened to us.
Yes.
So we have a lot of conversations about the kind of recent state of just sort of broad proclamations, especially by Donald Trump, but by really the gambit of Republican candidates. Some say it in positive language, some say it in negative language. We're only going to let Christians in, or we're not going to let Muslims in. Regardless of how you say it, you're saying the exact same thing. My question is it so clear that that's not allowed under the Constitution, A, and B, even if it were allowed under the Constitution, should we go beyond the Constitution?
So do you want to answer the immigration law?
So, it's interesting. There was this very interesting op-ed in the New York Times by Peter Spiro that received a lot of criticism because what he says is, although it would be constitutionally viable and legally permitted under the Immigration and Nationality Act, it's not ethically desirable. And I don't know that that's right. I think that what
the first part of that.
Yeah, it is definitely not ethically. Yeah, I would say it's definitely not ethically desirable, but I think it's a stronger defense. So basically, the federal government has the ability to decide who to admit to this country and who to exclude. And there's a doctrine called the plenary power doctrine that suggests that federal executive branch decision-making on those grounds is subject to a plenary review by the judiciary, meaning the judiciary doesn't step in. And historically, that's especially been the case when national security is concerned. And so the question is, when you have, it's the same tension that Dale was talking about, when you have the civil rights and civil liberties, obvious discrimination on the basis of religious beliefs or national origin, and butting up against this ability to regulate in the name of national security, where does that balance fall? And I think there are actually really good arguments for why the standard as applied, contrary to Justice Scalia, would be different in our current political landscape than it was, half a century ago or earlier. But I think there are arguments that could be made under the Immigration and Nationality Act that the executive, at least as an initial matter, can claim the discretion to exclude people from certain countries on the basis of national security. So it's not a totally satisfying answer, but.
So I have a question on the issue of citizenship. So I know that in the Japanese Americans case, 2/3 were, as you mentioned, 2/3 were citizens, and I think reparations were only paid to those who were either citizens or permanent residents. The rest were not paid, and I'm wondering to what extent does citizenship really matter in these cases? Of course, when you think about citizenship, I guess it's kind of like an indication of belonging or loyalty in a way, but you can also violate the civil rights of people who are, they reside in the U.S. if they're not citizens of the country or permanent residents, as that is sometimes as another group. So I'm wondering, I guess, to either one of you, what extent does it really matter?
This is actually something we were talking about earlier, which so David Cole, constitutional law scholar, has this book, Enemy Aliens, from actually almost a decade ago now, where he makes this argument that the policies that are initially applied to aliens eventually get applied to citizens. And he makes the argument from historical terms. This book was published in 2003 or 4. At this point, we see that same thing happening now, where you start having preventive detention large-scale kind of detention of individuals based on this idea of future dangerousness, and that comes up initially with respect to immigrants. Ultimately, the same, different forms, of preventative detention, but the same idea then get applied to citizens through, say, the criminal justice system and the expansion of material support laws and the use of entrapment and other aggressive investigation techniques and so forth. So I think one way of answering the question, one way of reading the question is, should it matter? And the other way is, does it matter? I think certainly from a historical and even contemporary point of view, distinctions based on citizenship do end up getting applied. So any protection that citizenship seems to offer initially, as a descriptive matter, ends up being put aside fairly soon.
And David Cole's book is called Enemy Aliens, and it's an interesting title because it's a term that's applied to both non-citizens and citizens in the context of the post-9/11 context in terms of framing. Which goes to
in 1942, when Japanese Americans were incarcerated, they were reclassified. Even the citizens were reclassified as enemy aliens in their social selective service cards. So they were considered, at least legally, partly aliens. Redress did apply to non-citizens, though, and they did get it. The only condition was that you had to be alive at the time the bill was signed for Japanese American, for you to claim your redress. And the difficulty with that, the idea of citizenship, is Japanese Americans were not allowed to become citizens, or immigrants from Japan. You could not become a naturalized citizen until 1965. And the same almost with Chinese Americans. Immigrants from China could not become citizens until 1943. In the middle of that war, it was a political reason because, we're fighting this racist, homophobic regime in the Nazi Germany, and we're not allowing our own immigrants here to become citizens. So there was pressure to have Chinese Americans become citizens or allow them to become citizens. So yeah, there is a difference, but for the Japanese Americans during World War II, their citizenship was taken away, both in terms of their rights and in terms of their actual status at one level of the government.
Other questions?
Yeah. I guess I'm curious what your thoughts are on the future threats to the broader Asian American community. Like last year was very interesting after the huge hack of government records. A number of Chinese Americans were accused of being spies, and that was actually found out to have not the greatest factual basis. So considering the fact that in these moments of attack, you will have history repeat itself, I found it encouraging that those charges were dropped relatively quickly. But what are some things that you're seeing in the rhetoric now, or in potential future obstacles?
I'm glad you bring up that point because for two reasons. One is that, yes, we have certainly seen in the last couple of years a spate of cases against Chinese American scientists, engineers, and others, accused of espionage or sending trade secrets to China and so forth. And some of these prosecutions have fallen apart, and then it turns out were based on the same kinds of assumptions that we've seen in these cases. So that is indeed happening right now. I think the bigger thing that it points to is that when we think about the internment or any of these particular examples, it goes back to a point Dale brought up earlier that, are these aberrations or are these, continuations to greater or lesser degrees of magnitude of some problematic practices kind of within our national security state, within our immigration policy? Why is it so easy to fall back on these group-based presumptions of disloyalty? And whether it's the prosecution of a Chinese American scientist that turns out to be based on nothing more than a combination of group-based assumptions and so forth, or the examples of these detentions or the other policies we're seeing. Why is it that it keeps recurring? And so I think that would be sort of my ultimate thing I would want to end with is just is the internment the aberration, or is there something deeper that is more continuous in our history and our present?
Yeah, in the last few years, 30 Chinese Americans were charged. Not one was convicted. And if you think back just 10 years ago to Wen Ho Lee, the celebrated case where the judge apologized to him in open court that what was done to him was just unforgivable. Accused as a spy, acquitted. Anyways, I see that pattern again, and if you take it in the larger context of what's happening in this country, the economic competition with China is driving a lot of these types of, I think, activities. And so I think when you go back even further, the killing of Vincent Chin in Detroit was because of the competition in the auto industry with Japan. They thought he was Japanese, and auto workers killed him. So there's also a societal context, a historical context as well, that we have to kind of look toward to see and understand, why is this happening? And is it partly because a pattern of group presumptions, like Shirin says, which I absolutely agree with, and also the time right now when we're competing with China for really world and economic dominance.
We have just a little bit more time, and I was just wondering if we could wrap up by you telling us, both of you, maybe a little bit about, core of what we've been talking about is this idea of a group presumption based on stereotypes and or fear that of one or two isolated incidents sort of reflecting on a larger group in the context of Muslim Americans or Muslim immigrants. What is the antidote? I think I find myself thinking this all the time, right? What are the litigation and advocacy strategies that the Asian Law Caucus and Muslim advocates and the ACLU and all these groups that are working on this, what is working? Because we don't want to. I would like to end on a happier note that there is something that could work.
We're all doomed.
Because sometimes.